Hi, everyone. Thank you for joining today's webinar on gender identity and transgender issues in healthcare. My name is Patricia Dean, and most everyone calls me Pia. You're free to as well. If you ever have questions on this issue or want to talk about it, I'd be glad to chat with you about these particular statutes and regulations that come into play. Before we get started, I just want to remind you, and especially since we're lawyers, that today's seminar is not intended to create a attorney-client relationship. We're not providing you with legal advice. This is just a general discussion of transgender and gender identity issues and how they interplay with healthcare. And so if you have specific issues, we urge you to contact your in-house counsel or your legal counsel to address those issues in particular. Now that we've gotten that out of the way, let's go to what I would like to cover today. First, I'd like to talk about the protections under the Affordable Care Act's new non-discrimination provisions. The ACA had some strong non-discrimination language in the statute, but on top of that, they issued last May very extensive final rules that deal specifically with gender identity and transgender issues. I'd like to talk about that. And as part of that, I thought I'd go over some of the Office of Civil Rights investigations and actions that have been taken so far under those new rules so that you get an idea of where OCR is getting involved. Next, I'd like to talk about the CMS Center for Medicaid and Medicare Services current and proposed protections. There are some currently, and they've also proposed some new, although they have not become final at this point. Then also there is the Joint Commission standards that affect lesbian, gay, bisexual, and transgender community. And those are very interesting because those are unlikely to change with the political winds. I'd also like to cover the most recent challenges to gender identity protections. There's been numerous, and I think that's part of what's leading to the confusion. And then finally, conclude with best practices and recommendations for treating transgender patients. The reason that we decided to add this particular webinar to our regular schedule is because we're getting lots of calls from providers who say, I don't understand what's required. I hear that there are new non-discrimination rules. I don't know if those are still in effect. I've heard that there's court actions that are trying to enjoin those or stop those from going into effect. And then, of course, we have new things coming out of the new administration and the like. So we wanted to talk about sort of all of those issues and where providers are now so that you know what you need to do in your particular office, clinic, hospital, et cetera. So I thought as a good way to start, we could go with a scenario. And I said that this is not an uncommon situation or an uncommon scenario. It would be probably an overstatement to say that this is a typical scenario, but it's certainly one that is common. And most every hospital has had a situation like this. Many larger practices have, and even some now smaller practices and clinics, even in rural counties, are starting to have this situation. So let's just take a scenario where a woman walks into your office, clinic, or hospital giving the name of Lisa Doe. Her driver's license, however, identifies her as Robert Doe and indicates her gender is male. Lisa indicates that she wishes to see a doctor for a physical examination and specifically wants to obtain a mammogram. The staff is concerned about how to do multiple things that are part of their normal tasks. They want to know which name and gender pronouns they should use when talking to or about the patient, which name they should use in the patient's medical record or on the armband in the situation of the hospital, whether they can ask the patient about her biological sex, in other words, her gender at birth, if it is relevant to her diagnosis and treatment, and how to address the patient's transgender status in the medical record. Do you leave it out? Do you leave it in? How do you deal with that? And the thing that we also find is that what is typical in these situations is that there is confusion by staff and some discomfort in which the patient picks up on and very often becomes defensive, argumentative, or feeling like they need to solve the situation for the staff. So that's the most common reason that I'm being called by providers is that they're dealing with this situation and they want to know how to deal with it better. So we want to talk about what is required and what are best practices in a situation such as this. So let's talk about the ACA. The Affordable Care Act had a specific non-discrimination provision in it. Section 1557 of the ACA states, an individual shall not, on the basis of race, color, national origin, sex, age, or disability, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any health care program or activity, any part of which is receiving federal financial assistance, including credits, subsidies, or contracts of insurance, or under any program or activity that is administered by an executive agency, that would be HHS, or any entity established under the Affordable Care Act. So very broad. So that language was put into place and went into effect in 2010. But like most statutes, they give sort of broad parameters of ideas. And then what HHS does is takes that broad statutory language and creates rules to effectuate the purpose and gives specifics. So just a reminder, Section 1557 of the Affordable Care Act prohibits exclusion, discrimination, or denials in health care. I think it's important always when you're looking at what HHS does or CMS does to understand sort of their purpose behind it. The central purpose of Section 1557 was to expand access, basically access to care and coverage, and to eliminate discriminatory barriers to access in healthcare, trying to get more people into the system, more people accessing healthcare. And it expressly recognizes that discrimination based on race, color, national origin, age, disability, and sex are prohibited in other civil rights statutes. So the ACA went out of its way to say that we're putting this Section 1557 in to prohibit this specifically in healthcare, but we think that it's covered in other statutes, and that becomes important for reasons we'll discuss in just a few minutes. And to give you an idea of is this a problem or not, in 2016, the Human Rights Campaign came out with their Health Care Equality Index, and it found that 56% of lesbian, gay, bisexual, transgendered, and questioning people reported experiencing some form of discrimination when receiving health care, and that was 70% for transgender individuals. So there's a perceived problem out there that CMS and HHS have specifically picked up on and said that there needs to be provisions to improve access to care and cut down on discrimination. So, as I mentioned, we have the broad statute, the ACA, which went into effect in 2010. Then last year, on May 18th, the Health and Human Services Office of Civil Rights, the OCR, issued final regulations implementing Section 1557 of the ACA. These regulations apply in part to every health program or activity, any part of which receives federal financial assistance from HHS, as well as HHS-administered health programs and activities. So a covered entity would include health plans, insurers, hospitals, and physicians, and any other providers receiving federal funding, including Medicaid and Medicare Parts A, C, and D. So it's very, very broad. I think that we are safe in saying that the HHS final rules that implement Section 1557, these non-discriminatory final rules, apply to most every provider. And the Office of Civil Rights has the job of enforcing these rules, and they can do that through investigations, fines, and the like. The final rules, I'm going to go through this in some level of detail because people who simply read the rule don't understand how we get to transgender and gender identity by just referring to non-discrimination based on sex. So the final rule specifically prohibits discrimination based on an individual's sex, their gender, pregnancy, childbirth, or related medical conditions, gender identity, and sex stereotyping. Those are all sort of unusual words. This is the first federal statute to ever prohibit discrimination on the basis of sex, and they use that exact term, on the basis of sex. It's a term of art in the statute. So it encompasses a lot of different things. So the HH provisions apply to transgender individuals because on the basis of sex is defined by the regulations to include gender identity and sex stereotyping. The HHS regulations protect transgender individuals in two key ways. One, there's expansive prohibitions on sex discrimination, which is then defined to include gender identity and sex stereotyping. And then they also have explicit protections accorded specifically to transgender individuals in the healthcare setting. So in other words, they use both expansive prohibitions on sex discrimination to include transgender and gender identity issues, but they also have explicit protections accorded specifically to transgender individuals in the healthcare setting. I want to point out that these regulations are currently under a preliminary nationwide injunction, and so they are not enforceable at this particular moment. However, and I get this question a lot, do we enforce these? Do we go forward with these protections? And our recommendation is yes. The preliminary injunction could be overturned at any point. There are several groups fighting it. Moreover, there are other regulations and statutes out there, this is what I was mentioning earlier, that specifically prohibit these kinds of behaviors. So we feel like it's a dangerous time in which to say we don't have to comply. I think the safer bet from a legal perspective, from your lawyer's perspective, would be to implement these protections for transgender individuals. So what does discrimination based on sex mean? Well, it means that women must be treated equally with men in the health care they receive and the insurance they obtain. Insurers can't charge women more, and women must be treated equally when receiving the health care that is offered. Individuals cannot be denied health care or health coverage based on their sex, including their gender identity or sex stereotyping. So an insurer cannot say, for instance, we won't treat a transgender individual, or excuse me, we won't cover a transgender individual. Likewise, it's very dangerous for a healthcare provider to say, we will not treat a transgender person, or treat them differently based on some stereotypical idea of what's male and female. Third, a covered entity may not, in providing or administering health-related insurance or other health-related coverage, deny, cancel, limit, or refuse to issue or renew a health-related insurance policy or other health-related coverage, or impose additional cost sharing or other limitations on the basis of sex. So again, an insurer can't deny coverage, limit, or charge more, or refuse to renew an insurance policy based on an individual's gender or gender identity. The next one is very, very important because it I think, speaks to the breadth of which these rules go. So categorical coverage exclusions or limitations for all healthcare services related to gender transition are per se discriminatory. That really takes a lot to get your arms around. What these new rules say is that if you have a policy that says coverage will be limited or excluded on the basis of the fact that the person is going through a transition, a gender transition, it is per se discriminatory and not legal. So that gives you an idea of how far these rules go and the extent to which, the breadth of which they cover. 5, individuals must be treated consistent with their gender identity, including access to facilities. So if someone comes into your office dressed as a woman, identifying as a woman, using a female name, they must be treated consistent with that gender identity. Next, providers may not deny or limit treatment for any health services that are ordinarily or exclusively available to individuals of one gender based on the fact that a person seeking such services identifies as belonging to another gender. That's the one that I get probably the most questions about. I've had many, many providers say to me, when I read that sentence, it says to me that I have to provide a prostate exam to a transgender male, and I have to provide a cervical exam to people who don't have a cervix. That is actually not right. The health services sought must be medically appropriate. So nothing in the new rules requires a covered entity to provide a traditional prostate exam to an individual who does not have a prostate, or a cervical exam to a person who does not have a cervix, regardless of that individual's gender identity. And so that becomes important to sort of start to set up this idea of our hypothetical, of our scenario of Lisa Doe. Does she get a mammogram or does she not? Since her birth identity was male. So I'll let you think on that one for a little bit while we go forward. Next, sex-specific health programs or activities are permissible only if the entity can demonstrate an exceedingly persuasive, and I put that in quotes so you know that comes right out of the statute, exceedingly persuasive justification. That is, the sex-specific health program or activity is substantially related to the achievement of an important health-related or scientific objective. That is so narrow that it is intended by HHS to not permit an entity of any kind to say, we're going to do something that's sex-specific and therefore be able to get around the transgender issue. So they say that there must be an exceedingly persuasive justification, and basically there has to be, the activity has to be substantially related to an achievement of an important health-related or scientific objective. So I think examples include things where the research requires either 2 X chromosomes or an X and a Y chromosome. And OCR has made it abundantly clear in the rules, in the commentary to the rules, that they will evaluate sex-specific health programs or activities strenuously, and only those programs that have legitimate reasons for excluding an individual on the basis of sex will pass muster. So the idea is to allow some exception, but not much of a one. The final rule does not resolve whether discrimination on the basis of an individual's sexual orientation status alone is a form of sex discrimination. This is the other question that I've been getting a lot. Well, there's many questions, but this is another question I do get a lot. Does the final rules, or do the final rules, address sexual orientation? And interestingly enough, while they go a long way in terms of gender identity and transgender, they do not deal with discrimination against gay people, basically. So the OCR makes it very clear that this protection does not extend to sexual orientation issues, but they make it very clear that they will evaluate complaints that allege sex discrimination related to an individual's sexual orientation, determine if they involve the sorts of sex stereotyping that can be addressed under the new non-discrimination rules. And they specifically say that, that the law will continue to evolve and that they will enforce 1557 in light of those developments, which is their way of saying, given their choice, the movement is toward extending these non-discrimination rules to individuals of, who are gay, basically, no longer taking sexual orientation or putting sexual orientation into the mix of non-discrimination rules. So let's talk about gender identity. These final rules go further than I ever thought I would see in my lifetime because they are very, very progressive. The final rules define gender identity as an individual's internal sense of gender, which may be male, female, neither, or a combination of male and female, and which may be different from the individual's sex assigned at birth. I want to just take a minute to get our arms around that. One of the first questions I got after the final rules were implemented, and I sent things out to clients, providers, saying these are the new rules. I immediately got a call from a provider friend who said, okay, how many boxes do I need now for gender? We used to have a gender that said male or female, and he said, and then we eventually went to male, female, or other. But now I'm understanding what these rules say is that a person can be male, female, neither, both. It can be a fluctuating issue, so it's no longer a fixed thing. So how many boxes do we need? And we worked our way through that problem, but it is an interesting idea that these rules specifically say gender is not binary. It's not one or the other. So providers have to be careful to implement in their intake procedures and throughout all of their clinical encounters this idea that gender is not binary and can be male, female, neither, a combination of both, or transgender. And a transgender individual is defined as a person whose gender identity is different from the sex assigned to that person at birth, so different from their birth sex. Whoops, went too far, sorry. What is sex stereotyping? So as I mentioned, the new rules apply both to gender identity and to this idea of sex stereotyping. They prohibit discrimination on the basis of sex stereotyping, which is defined as stereotypical notions of masculinity or femininity, including expectations of how individuals represent or communicate their gender to others, such as behavior, clothing, hairstyles, activities, voice, mannerisms, and body characteristics. So you're no longer able to discriminate. These rules specifically say discrimination is improper on basis of sex stereotyping. This is, I think, particularly difficult for employers and providers who may not know or know how to approach a person. Interestingly enough, the Colorado State Supreme Court has a person working on gender identity issues, and I went and met with her, and she's a fascinating person. She wears a button that says, "Ask me my preferred pronoun," and she wears this button on her lapel. And so, of course, when I walked in, I said, "Okay, what is your preferred pronoun?" And she said, "she." And she then explained to me that she has a male-sounding first name. She dresses in a way that would be more stereotypically male, and she said she's often identified as male. And so this whole issue is, how do we approach individuals where we're not sure what their identity or what their preferred identity is? And so this idea that you can say, well, somebody walked into my office dressed like a female or dressed like a male and acted like a male, and therefore I took them as male, is probably not adequate. We're going to have to do things that don't involve sex stereotyping. The final rules add an additional reference not found in the proposed rule that clarifies that sex stereotyping includes gender expectations related to the appropriate role of a certain sex. So the OCR adopts the position that sex stereotypes encompass not only stereotypes concerning the biological differences between the sexes, but also includes stereotypes concerning gender norms. Again, this is very broad and very, very progressive. Sex stereotypes can also include a belief that gender can only be binary. This is where we get to the binary language, and thus that individuals cannot have a gender identity other than male or female. The gender identity spectrum includes an array of possible gender identities beyond male and female. This is all from the federal regulations. This is the discussion that HHS is having, and you can see how broad this is. So here's an interesting situation that came to this particular person at the Supreme Court that I was just mentioning. An employer came and said, we have a situation where we have an employee who has two different, excuse me, jobs at our business. And for one of the jobs, excuse me, she identifies as female and uses a female name and has an office in one part of the building. For the other position that she holds in our company, he identifies as male, uses a male name and male pronouns, and we don't know how to cope with this. And the ultimate recommendation, this was not a rule, this was not a court case, but the ultimate recommendation from the Supreme Court's office was to go ahead and treat that person as female in one part of the building and male in another part of the building, but to require that person to identify how they wanted to be addressed at different times and in different positions so that people didn't have to guess. So I guess the long and short story is, when someone walks into your office and you're not sure, the proper thing to do is to ask the preferred name and the preferred pronoun that that person would like to be addressed by. That involves the sex stereotyping. So how does this all shake out? We only have a couple of, basically 6 months of OCR investigations, and these are investigations by the Office of Civil Rights for matters that were reported as being discriminatory under these new final rules. And I think that they're actually helpful. So I thought I would give you an sampling of some. The first is a hospital policy that automatically assigned a male spouse as a grantor, which means their sole financially responsible party, when a female spouse received medical services. But when a male spouse received services, the female spouse would not automatically be assigned as grantor. So basically they were treating men and women differently when their spouses came in for medical care, whether or not they were grantor or financially responsible for that person. It was reported to the OCR investigated, and ultimately they worked with the hospital so that the policy was revised to ensure equal treatment. Okay? Another one, complained from the male victim of domestic violence that he was subjected to rude comments by hospital staff. Basically, he was being told that he was effeminate and harassed on the basis that he was not strong because he was the male victim of domestic violence. Again, the abuse protocol was revised, and there was training for staff on identifying and assisting abuse victims, whether they be transgender, whether they be male, female, and the like. This next one is a really interesting one, and obviously relates back to some degree to our hypothetical, and it comes out of Colorado. We had a wellness program here that denied a transgender individual mammograms because she transitioned from male to female rather than female to male. So this was a person who was male at birth, but who came in and said, I want a mammogram. And he had a very good, he had a very good reason, no, she had a very, I apologize, she had a very good reason for wanting a mammogram, and that was that she had taken or was taking female hormones. And there are studies out there that say that the use of hormones increase the risk of breast cancer. What was interesting was that the Colorado Wellness Program's policy was based on CDC guidelines. And so what happened is the wellness program went to the CDC and raised the issue with the CDC to say, this person seems to have a point, we were just following your guidelines, and the entire CDC protocol was changed. So again, this program allowed mammograms to transgender women who were taking or had taken hormones. And I think the takeaway from that particular situation is that some cases require a case-by-case examination. There may be times when a person, a transgender person, comes in and asks for a service that is wholly inappropriate medically. On the other hand, if the person has a reason for requesting or suggesting that they are or should be eligible for a particular course of treatment, I think it's worth listening to the reasoning. And again, the CDC changed its entire policy based on this particular case. Other examples, insurance company denied transgender individual gender reassignment surgery on the basis that they called it cosmetic surgery. Again, we go back to that a few minutes ago when we talked about that very broad language, that wholesale refusal to cover gender reassignment surgery is per se discriminatory. It doesn't mean that you can't have some policies, but a blanket approach does not work. So ultimately, that insurer had to change their policy so that requests for gender assignment surgery were determined on a basis of medical necessity. If a doctor came back and said, for this person's health and well-being, gender reassignment surgery is appropriate, then the insurer was required to cover it. Next, just a very simple, common, I shouldn't say simple, a very, very common problem, and we hear about these all the time. A man who received transportation services to a doctor's appointment from a private medical transportation company complained that multiple drivers harassed him because of his feminine gender expression. This, of course, is not a provider. This is just a service that's getting people to a provider, but that goes to show you how far that the OCR can reach. So because this particular company was providing services that were related to healthcare, the OCR came in and there was an agreement between the entities that the staff would receive training on how to avoid sex stereotyping and the usage of appropriate terminology. Again, preferred name and preferred pronoun, but also without the harassing behavior. The next is a medical center received multiple complaints from transgender individuals about procedures, and I don't mean this as medical procedures, but just intake procedures, including questioning in public waiting rooms regarding the gender listed on their patient forms and not allowing transgender individuals to change their gender in medical records without documentation of a completed gender reassignment surgery. This also happens quite often. It is a very, very bad policy to allow a nurse in a public waiting room or an intake person of any kind, or a physician, doesn't matter, to say to somebody, hold on, I show here that you're male, but you look female. This is, again, considered part of discrimination, harassing behavior. So the idea is to create a policy for your particular entity that is sensitive to these issues. And the real problem here was the questioning in a public waiting room. The other aspect of this is, when can you change a person's gender in their medical record? It used to be that we looked at it as whether there was a legal change, whether a person had legally changed their driver's license and the like. Some hospitals and clinics use the idea of whether or not there had been a completed gender reassignment surgery. So this would include what is colloquially called top and bottom surgery, but basically a complete gender reassignment. That has fallen by the wayside, and the attitude now is to be sensitive to what a person wants to be called and known as, and the pronoun that they want used. And we'll get to how to deal with this in medical records, but a policy that requires a completed gender reassignment surgery, it probably will not pass muster any longer. So that completes the new final rules under the non-discrimination policy, Section 1557 of the ACA. And we're going to come back to that because obviously the ACA is under a significant challenge right now. There's obviously efforts going on to repeal and replace it. And the question is, what's happening with these protections? Likewise, as I mentioned earlier, there was a court in Texas that has enjoined the implementation of these policies. So the question is, what do we do with them? And again, what I would say is we still counsel our clients to go forward with these rules as they are right now, because the preliminary injunction could be overturned. The ACA, the repeal and replace of the ACA may not be successful, and we could end up with the ACA being the law of the land. So, for some period of time to come. So the question is what to do, and we're continuing to recommend that providers follow the non-discrimination rules. But what else is out there? Because I think it is very, very likely that either through administrative action or executive order that these final rules are going to be undone. So the question is, are there other things out there that require non-discrimination policies? CMS has both current protections and proposed protections. Their current are under their conditions of participations for hospitals. And these are basically limited to hospitals, obviously, conditions of participation, and says that hospitals shall not restrict, limit, or otherwise deny visitation privileges on multiple bases, including gender identity. The same thing is true for critical access hospitals, and basically it just goes to visitation. But CMS, following probably the lead of HHS, which it's under, of course, has also come up with some proposed protections. In June of last year, they proposed another rule under Section 1557 of the ACA entitled Hospital and Critical Access Hospitals Changes to Promote Innovation, Flexibility, and Improvement in Patient Care. The rule would require hospitals and CAHs to establish and implement a policy prohibiting discrimination on several bases, including gender identity. And CMS's reasoning on this is discriminatory behavior can affect perceived and actual access to and effectiveness of health care delivery. So far, the rule has not been finalized. The comment period ended on August 15th of last year. The final rule has not yet come out. And this, by the way, would add new section 482.13I to the patient rights section of the hospital's COPs to prohibit discrimination and require written policies prohibiting discrimination. So again, this would apply only to hospitals and critical access hospitals. And we don't know what the administration's response to this would be. It is likely, I think, that Secretary Tom Price may put any changes, any final rules on hold pending what happens with the ACA. So that covers what CMS has, what the Centers for Medicare and Medicaid Services has in terms of protections. But the other big one is the Joint Commission, and the Joint Commission has gone a long way in terms of gay and transgender rights. As most of you know, the Joint Commission is an organization that surveys and credits various healthcare organizations, hospitals, nursing homes, federally qualified health centers, physicians' offices, and even home health care providers which comply with its standards. And they have, as you know, many standards, but their non-discrimination comes through in several, but most clearly in RI 0101, element of performance, which states that hospitals must prohibit discrimination based on age, race, ethnicity, religion, culture, language, physical or mental disability, socioeconomic status, sex, sexual orientation, and gender identity or expression. So that covers just about everything. Other standards that the Joint Commission have in their overall package include standards that require patients to be treated in a dignified and respectful manner and in ways that respect the patient's culture and personal values, beliefs, and preferences. And preferences is a big one. The Joint Commission has a lot to say on this. And I've been through a Joint Commission site visit, which dealt a lot with some of these issues in a rural hospital. And it was fascinating, the revisions that needed to be made to be more sensitive to gay and transgender issues. To provide guidance for implementing these standards, in 2011, the Joint Commission came out with the LGBT Field Guide to address the provisions of care, treatment, and services of the LGBT population. The Joint Commission suggested multiple actions, including the following, and I think these are important because they give you an idea of the sensitivity to issues that the Joint Commission is interested in maintaining. So they say there must be a welcoming environment that is inclusive of all patients. The hospital should immediately post non-discrimination policy or a patient bill of rights. Ensure that waiting rooms and other common areas reflect and be inclusive of LGBT patients and their families. Create or design a unisex or single stall restroom. So this is the idea of how do we deal with bathroom use. Single stall or unisex bathroom seems to be the approach that most everyone in healthcare is settling on. Ensure that visitation policies are implemented in a fair and non-discriminatory manner. Foster an environment that supports and nurtures all patients and families. Avoid assumptions about sexual orientation and gender identity, including on the basis of appearance. Facilitate disclosure of sexual orientation and gender identity, but be aware that disclosure is an individual's process. So an individual baby, anywhere in that process. So we want to, or the TJC wants to facilitate an environment where a person can self-disclose, but also understands that that person may not be ready for that particular move. Use forms that contain inclusive, gender-neutral language that allow for self-identification. Use neutral, inclusive language in interviews and when talking with all patients. This next one I think is very important. Listen to and reflect the patient's choice of language when describing their own sexual orientation and how the patients refer to their relationships or partner. And then provide information and guidance for the specific health concerns facing lesbians and bisexual women, gay and bisexual men, and transgender people. So that's how the Joint Commission deals with that. Is that important? I think it is, because the Joint Commission provisions predate the final rules, obviously, that went into effect or were published in 2016. These Joint Commission standards predate the final rule and, in fact, were implemented shortly after the passage of the ACA. They're not reliant on the ACA. So these standards are becoming the basis for care in most hospitals, lots of federally qualified health centers, some doctors' offices, even home health agencies. And while entities may be accredited by someone other than the TJC, this is the movement that accrediting agencies are moving toward. I think that they're moving toward this sort of approach of sensitivity to transgender issues. So let's talk about these other challenges. On the eve of the effective date of the new HHS Regulations, the final rules that we've been talking about, the United States District Court for the Northern District of Texas issued a nationwide preliminary injunction stopping HHS from enforcing the Section 1557 regulations prohibitions against discrimination with respect to pregnancy and gender identity. So they went after both pregnancy and gender identity. The case is called Franciscan Alliance versus Burwell, Burwell being Secretary Burwell. And I want to give you an idea of how interesting this was from a legal and probably even a political standpoint. As I've mentioned, the rules were published in June or May of 2016. They were to go in effect on January 1, 2017, so this last January 1st. Saturday was December 31st, and the court actually issued its ruling, which is many, many pages long. It's got to be close to 25 or 30 pages, on Saturday, and came out and said, I'm going to enjoin this. The other thing that the court did that was very unusual is they did a nationwide preliminary injunction. So usually courts enjoin for their particular region. The Colorado Supreme Court would enjoin something in Colorado. But this case, and it happens every once in a while, in this case, a federal district court judge in Wichita said, I'm enjoining the implementation of these 1557 rules and regulations for the entire country, for everyone. And the court found that the gender identity and termination of pregnancy provisions of the final rules contradicted existing law, exceeded statutory authority, and as applied to religious entities, likely violated the Religious Freedom Restoration Act, the RFRA, and just basically said this is going too far. Now, what was interesting is that there was an assumption that there would be a hearing on to make the preliminary injunction permanent. So what is required for a preliminary injunction is not as great as what's required for a permanent injunction. And the ACLU got involved on the other side. They started briefing, and there was an assumption that the court would hold a full-blown hearing before deciding whether to make the injunction permanent or doing away with it. And there has been no further action by the court, and that's likely because of efforts to repeal and replace the ACA. Obviously, if the ACA is repealed, these rules and regulations all disappear into the dust. And so that's probably the likely reason that the court has not taken further action, although I know that the ACLU is pushing them to do so. There are two other cases pending in North Dakota that, like the case in Texas, seeks to stop the enforcement of the final rules and enjoin enforcement of Section 1557. And even if the ACA is not repealed, Secretary of HHS Tom Price can undo many of the regulations adopted in 1557. So there is great doubt about whether these final rules or how these final rules will be implemented in the long term. But right now they're still on the books. Also, other challenges to these kind of protections. President Trump has rescinded President Obama's bathroom bill, which you may have remember was going on, which basically said students can use the bathroom that comports with their gender identity. And the Supreme Court was set to hear a case involving Gavin Grimm, which was the Gavin Grimm versus Gloucester County School Board, but recently withdrew that from its docket on the basis of President Trump's order. So when President Trump rescinded the executive order put in place by President Obama, the Supreme Court said we no longer have a basis on which to hear this, and so they've rescinded that. The matter will now likely be decided on a state-by-state basis. So we all know that North Carolina has a bathroom bill, Texas has a bathroom bill that don't comport with President Obama's order, and now the general wisdom is, the general thinking is that that will be decided on a case-by-case basis. And then interestingly enough, on February 2nd, and that should read 2017, I apologize, so just 2 weeks ago, there was a leaked draft of an executive order. And by the way, this leaked draft was from Investigative Fund, which I don't know, but they leaked a draft of this executive order, which is called Establishing a Government-Wide Initiative to Respect Religious Freedom, which would expand religious protections, roll back anti-discrimination protections for the LGBT individuals, and make it easier for employers to deny contraception coverage. So that order was leaked. Since then, since the leak, there has been no indication of when it might be put in place, whether the executive order may be signed, or whether it will be at all. I suspect that that's for lots of different reasons. One, whatever replaces the ACA may have these kind of protections in, so it may not be necessary. The other thought is that with everything that's going on right now with healthcare or with other controversies around the administration, that they may not want to put this out and incite yet more concern from certain populations. Obviously, it would have a strong support from parts of the community, but there would also be widely disliked by other parts of the population. So we have a leaked draft of the executive order, but we don't know what's going to happen yet. So the effects of these challenges. Obviously, in light of the election and the vows to repeal and replace the ACA, the preliminary injunction in the Franciscan Alliance case, the other legal actions in North Dakota, and the recent executive orders, knowing what is required of providers is very difficult to ascertain, which is the reason we are doing this webinar today, but also the reason that I think my phone rings so much more often these days with very specific questions about, I have somebody in my office, what do I do right now? So obviously, as I've discussed, the ACA's final rules, I think, are in significant doubt. But I want to point out that the Joint Commission standards and recommendations are likely to remain in effect. They are being mirrored by other accrediting organizations. Likewise, HHS and other entities may seek to enforce protections through other statutes, including Title VIII of the Civil Rights Act. So we know that there's a movement in this direction. Likewise, many providers are unlikely to undo the non-discrimination procedures that they've put into place to address gender identity issues. And again, if hospitals are doing one thing because of the JTC standards, it sort of becomes the norm that then is copied and followed by other providers. So the safest approach is to comply with existing regulations and guidances that we've received from these kinds of organizations. Now, I know that not everyone has that opinion. Some believe that you can push the envelope a little bit. From a legal standpoint, that's probably the safest thing to do. If, on the other hand, if an entity has very specific religious objections or moral objections to some of these protections, then they have some basis for not taking on those kinds of protections. But I think it needs to be done in a very knowing and thoughtful, deliberative approach to taking that on. I've now worked with several different organizations and entities which have grappled with these particular issues. And what I could tell you from watching the discourse that's occurred, watching what has happened when people have not followed through with these standards and the like, is that there is considerable social momentum right now for transgender rights and protections for gay and transgendered populations. In one of the most interesting cases I worked on, an entity decided that they did not want to extend certain services, and they got such a pushback from their existing patient population. So I feel like we're at the crossroads of both a social and political firestorm. And my general bottom line to providers is this, and then this is just my opinion, but no matter who's in the White House or prevailing politics at the moment, most commentators, including me, believe that gender identity and transgender protections are here to stay. Numerous agencies and industry groups have drafted explicit protections for transgender patients. Equally important, patients, and by this I mean younger and younger patients of all types, will increasingly expect providers to be sensitive to gender identity issues, and that's really what we're finding. However, if an entity feels like they simply for religious or moral reasons cannot accept these kinds of non-discrimination policies and don't want to put them in place, then I think it's very important to, like I said, in a deliberative process, but also probably in some sort of written document, have an explanation when patients are asked, when patients ask about a particular policy, so that you have a response. There are lots of protections under the Religious Freedom Act. I think that we'll see more and more of those. But for those who don't have a moral or religious reason, I think those entities do need to comply with these transgender and gender identity protections. So with that, let's talk about best practices. And I think let's go back to Lisa Doe, our scenario. Staff should initially refer to the patient by the name provided. So if someone comes in and says, I am Lisa Doe, it's fair to assume that you are dealing with a woman or a transgender woman. If in doubt, ask the patient his or her preferred name and pronoun, and then that name and pronoun should be used throughout the encounter, obviously without with any kind of harassment or making fun of or whispers or the like, obviously. I have had a physician call me and say, I have no idea what the gender of the person who's just walked into my office is, and I don't know what to do. The simple answer is ask. Just go ahead and ask what the patient's preferred name is and what their preferred pronoun is. It's becoming actually quite common. In this particular case, the person had in their intake paperwork identified other but not explaining other, not male, not female, but other. And then the name was not indicative of male or female or particularly indicative, and so they just weren't sure how to address this particular patient. So the question, I think the answer to that is ask. Providers should have a process for recording a legal name change of a transgendered person, just as it would for a marital adoption or other name change. The best practice is use the same approach for unofficial name changes, and providers should also have a process for recording and using a patient's preferred name and pronoun. So that may be as simple as just a note on the inside of the file or a parentheses on the name of a particular chart. You can do it any way you want, but a procedure, I think, is important to have in place. However, so then we get to the question of how do we deal with the medical record? And the medical record should note that the patient is transgender so that medically appropriate care is provided. What you don't want to do is have a physician, probably not in your office, but a physician down the road who requests a patient's records. You don't want that doctor thinking that they are dealing with a biological female as opposed to a transgender female, for obvious reasons in terms of examination. We think the best approach is to note the patient's birth gender in the medical record, but use the patient's preferred name and pronoun for all of their charting. So we typically start with, example, Lisa Doe is a transgender female, and then proceed to use that female pronoun throughout the remainder of the note. But that way, with each SOAP note, each clinical note, it starts with X is a transgender female, so that the physician and any subsequent treating provider will know that that person is transgender for purposes of determining their appropriate medical course. Obviously, this approach allows for accurate information in determining medical treatment while remaining sensitive to the patient's gender identity, and equally important, avoiding complaints of discrimination from to the Office of Civil Rights, which can then investigate and require changes. We've had a situation where the patient objected to being identified or having their gender identity at birth noted in the medical record. The person wanted to be known as a female for all purposes and have no mention of a male birth identity anywhere in the record. And my approach to this is to explain the need for a complete medical history in order to determine the patient's appropriate course of care and not give in to that kind of request, because I think it's important for medical reasons. And that, by the way, worked. When the provider sat down with this particular patient and explained to her what the issues were and how important it was, the patient said, okay, now I get it, but I want my preferred name to be the name on the chart, and I want to be referred to as that. And that was easy to comply with. So with all of discussion, I want to come back, though, and remind you that there is no specific prohibition against a provider using the patient's legal, that being their non-preferred name in the medical record. However, if you're going to take that approach, we think it is important to tell that patient that up front, the transgender patient that up front, that is the office, clinic, hospital policy, whatever it is, but to let the patient know that up front. So then let's talk about treatment decisions. With respect to treatment decisions, remember that covered entity health plans may not limit or deny coverage of a claim, require additional cost sharing or on the part of the patient, or otherwise restrict coverage. So for any health services specifically related to gender transition, you can't do that. You can't discriminate against gender reassignment surgery on a wholesale basis. And for any services that are ordinarily or exclusively available to individuals of one sex because of an individual's sex assignment at birth or gender identity differs from the one in which services are ordinarily or exclusively available. So just remember that those are the two strong requirements when determining what is appropriate treatment-wise. This means, for example, that a covered entity may not deny a transgender man coverage for ovarian cancer. If the patient still has ovaries, even if he identifies as male, you cannot deny screening for ovarian cancer. Procedures intended to assist in an individual's transition not based on discrimination are more difficult to determine. So as we said, any wholesale decision to not cover transition services is per se illegal. However, if it's not based on discrimination, then it's a more difficult situation. And for example, if a plan covers hysterectomies for cancer but denies them for treating gender dysphoria, even when the provider says it's medically necessary, the OCR might scrutinize that coverage policy. So just remember that any decisions to deny coverage to a transgender individual will be highly scrutinized and cannot be done on a wholesale basis. So if a covered entity covers certain kinds of elective procedures that are beyond those strictly identified as medically necessary or appropriate, it must apply the same standards to its coverage for comparable procedures related to gender transition. The situation that I've seen is a physician who agreed to a breast reduction for a female to address back pain, but refused to provide a breast reduction to a transgendered man on the basis that it would be improper, that it was a completely elective type of surgery. And there the OCR came back and said, nope, that's wrong. If you provide elective breast reduction surgeries for any reason, you must, for any elective procedure, then you must also do the same for the transgendered individual. I hope that makes sense. And with respect to medically necessary treatment, providers should consider both the patient's gender at birth and any other additional factors that may affect the patient's health. So returning again to Lisa Doe, a provider would typically not be required to perform a mammogram since she was male at birth. However, because of the hormone therapy, she was at higher risk for breast cancer, and therefore mammography is appropriate. So again, a case-by-case decision can be important. Lastly, I just want to deal with bathrooms because I get lots of questions about bathrooms. As I've mentioned, President Trump has rescinded President Obama's order on bathroom. We still believe that the best practice is to provide at least one individual bathroom that is not gender specific. These individual bathrooms, unisex bathrooms, have become basically the best approach for practices dealing with it. Dealing with these kinds of issues. It's not, you don't have to make all bathrooms transgender. There can still be a male and female bathroom, but it is a good idea to have at least one non-gender specific individual bathroom to deal with those sorts of situations. So I hope that I've answered at least some of your questions. If you have others, I'd be more than glad to talk to you about them. You should feel free to call or email me. I'm glad to discuss. The final slides just are a reminder of the other webinars that are free on our website. Articles, forms, and checklists all can be found at our website. There's obviously no cost for those kinds of things. That's a description of how you get to there. And a final reminder that our next webinar will be on April 27th, and that will be dealing with immigration changes in the Trump administration and trying to anticipate what that means in the healthcare space. And then, again, just websites for other health-related publications, webinars, articles, and the like. I thank you very much for joining us today, and I know I'm at the end of the hour, so I will disconnect at this point. Very much appreciate your attendance today. Thanks. Bye-bye.